Well, good Monday morning. Thanks so much for staying up. You know, slip and fall's the common term for a broader legal area called premises liability, which holds that owners and occupiers of property may be legally responsible for accidents and injuries that occur on that property. So how can you be sure if you have a claim, and what do property owners need to know to protect themselves from a lawsuit? If you've suffered an injury at a home or a business due to unsafe conditions on the property, we want you to give us a call. We have a pair of expert attorneys standing by. We'll take your questions live at 803-442-4551. But here's what's coming up on the docket the next several weeks leading up to the holidays. If you cannot afford an attorney, we'll give you some options on December the 4th. We'll examine holiday traffic accidents on December 11th, and then driving under the influence on December the 18th. Well, joining us each and every week from the Vic Hawk Law Firm is Vic Hawk, and good Monday to you, sir.
Well, good morning to you.
Indeed.
Yeah. We want to thank all you night owls that stayed up to watch the show tonight.
Especially with the turkey and the tryptophan, you think they'd be out, right?
Yeah, that's exactly right.
But no.
So thank y'all for staying up and staying with us. We've got a bunch of good ideas and good information to give you tonight. And I want to remind you again, there's a benefit by the Augusta Riverhawks for J.D. Paw and his family, the officer who was tragically killed last month. It's December 17th at the arena. Tonight we're going to talk about slip and falls, and we're going to give you some information that's very important to you in deciding what you can do to protect you and your family. And tonight I brought on a good friend of mine, Bill Sussman, who I practiced with and shared office space with for a number of years. He's practiced in the field of civil litigation, personal injury, slip and falls, automobile accidents, as well as criminal law. He's licensed both in Georgia and South Carolina, and he can really help you in the event that you or your family's been injured as a result of a landowner failing to make their premises safe. Bill, can you explain to our viewers what they should do if they're injured on the premises of another and it wasn't their fault?
Well, typically what we commonly call a slip and fall would be, as you know, if there's, for instance, a classic example would be a substance such as maybe some shampoo that leaked out of a bottle. I think you had a case similar to that several years ago. Or perhaps if you're in a grocery store, you might slip on a lettuce leaf or banana peel, classically. And generally what happens is if you do fall down and hurt yourself, you should report it to the store owner right away. If you're able to, and of course a lot of people are in shock, they're embarrassed when it happens, but if you have the presence of mind to do it, you want to try to see if there's anyone available that can, who may have witnessed the fall. You get their information, and generally you try to see what you slipped on. What does it look like? A store owner is not automatically liable for your injury. It's just not a no-fault type of situation. You have to show that they were negligent, that they failed to do something they should have done, like perhaps inspect the premises on a regular basis, and maybe could have avoided that substance that was on the floor that you slipped on. Or if it's unsafe condition of some kind, or there's a problem with the premises, a defect of some kind, that may require some more elaborate investigation, but the main thing is to make sure that you report it to the store owner right away.
We do actually have our first call of the morning. Bethel from North Augusta joining us. Bethel, you're a trooper. Thank you for staying up.
You're welcome.
Certainly. Explain to Bill and Vic what is your situation?
When I moved in, the place was infested with rats and fleas and ticks.
Okay. Have you had an opportunity to talk with your landlord?
Yes, and they sent someone in to spray, and it did no good. And then they sent someone else to spray, and that has done no good.
Bill?
Sounds like my first apartment in college. Well, the landlord has to provide a suitable premises for your enjoyment of the premises. And if the premises are unsafe, they do have some responsibility in providing you a clean and safe environment. And unfortunately, if they continue to fail to provide you with an environment that you deem to be safe, then if you can either try to force them to make the premises safe, or in the alternative, you may just have to move out. That's the problem with landlord-tenant situations like that.
Well, we are also joined another caller in South Carolina. Sally is not calling from Sally, but another part of South Carolina. Are you there, Sally?
Yes.
Okay, super. I guess I think the attorneys will appreciate this. You sort of have a preventative question, kind of a what-if question. Is that right?
Yes.
Okay. What is your question?
Okay. Like I work in a house taking care of an old lady. Now I was saying to this old lady, if I fall and hurt myself, can I sue?
Okay. The lady asked you that?
Yes.
Okay. It's her house?
Excuse me?
Is it her house?
Yes.
So she falls in her house. She wants to know who she can sue?
Yes.
Okay. Well, she's the owner of the premises, and if it's an unsafe condition in her house, that would be arguably her responsibility. She couldn't sue anybody. But of course, if it turns out that she's trying to say that there was something you should have done in taking care of her, I suppose that she could try to say that you should have done something as her caretaker, caregiver to make sure she avoids this unsafe condition. That's a pretty tricky question. If I were you, I'd make sure that some third party perhaps comes by the house on a regular basis to see that you're doing everything you're supposed to do to take care of her and not letting things be on the floor that she could fall on.
Sally, are you worried about if you fall as well?
Yes.
Well, Sally, if you fall, if there's some condition that you weren't aware of, then you may be able to file a claim. But based on the lady asking the question, I'd make sure I have some liability insurance covering you as well, because if she were to fall and she were to be under your care and you failed to do something that you should have done to prevent the fall, then you might have some exposure.
Okay.
Right.
Yeah.
Well, we're going to take some more of your telephone calls after we pay a few bills. The phone number is 803-442-4551. Just kind of turn down your television set. Try to use a landline if possible. Stick around. You're watching News 12 Law Call.
Broadcaster Neil Gordon, and from the Vic Hawk Law Firm, Augusta attorney Vic Hawk, known as a tough courtroom fighter, helping injured people for more than 30 years, plus guest attorneys from across the CSRA. Your rights, your calls, live. News 12 Law Call.
Hi there, more of your calls on slip and falls in just a moment. First though, if you're approaching your golden years, you may be hearing the term power of attorney more often, but what does it really mean? Well, personal injury attorney Reed Sanders explains in tonight's legal brief.
A durable power of attorney can be the most important estate planning document you have, even more important than a will. A power of attorney allows someone you appoint as your agent to handle business transactions for you. Your power of attorney should be drafted to fit your specific needs and spell out the things your agent can and cannot do on your behalf. Your agent's power could include making deposits into your account, writing checks on your behalf, buying or selling your home, and making charitable gifts. The power of attorney should state whether your agent may handle important accounts such as life insurance, IRAs, or a 401k. You can give your agent the right to make medical decisions for you, but this power must be specifically stated in the power of attorney. Power of attorneys are too important to rely on a fill-in-the-blank form. See a lawyer who specializes in estate planning or elder law to make sure that you are getting what you need. I'm attorney Reed Sanders of the Vic Hawk Law Firm. Back to you.
Thank you, Reed. We're rejoined by attorneys Vic Hawk and Bill Sussman, and our topic tonight, slip and falls. And we're joined on the telephone by Debbie from Augusta. And Debbie, we understand you had a pretty bad fall. Is that correct?
Correct.
Where did it occur?
It occurred back in May in Atlanta. I was at the airport, and I was in between flights, and there was a spill on the concourse, and I fell. And the airlines took the report and said they were responsible, gave me a claim number, and said send all medical bills to them. So I did. And then they called me back and said that they were not responsible because it was on the floor, not the carpet area. And so the airport was responsible. Well, then it got sent down to another company and another company. I mean, it's been like 4 different companies, and nobody wants to take blame or take responsibility for it. And I've tried talking to a lawyer, and no one seems to want to deal with this. Meanwhile, I'm like $6,000 worth of doctor bills. And I just, there's a report, there's doctor reports. Like I told them, the airlines I talked with the airport, the security will have the tape of the accident happening. And I'm just sort of at a loss of what to do next.
Debbie, I can tell you, Bill Sussman and I do these kind of cases all the time. And what you're running into is the same kind of problem that many other people that are injured under similar circumstances run into. We talked to you at the beginning of the show about things you need to do in the event that you're injured on another's premises as a result of the negligence of another. What you should do in circumstances like that is, of course, people that are around or witness your fall, you should get their name and phone number. Most everyone has a cell phone now with a camera on it. You should take a picture of what occurred. Because what you're going to be very surprised at now is video that supposedly showed your injury is not going to be available or lost because of the length of time between the time that you've submitted your claim and the time that this occurred. Witnesses are going to disappear. Employees are no longer going to be employed with them, and you are facing a mess. In addition to that, because it's at an airport, it's under an authority, and there's a time limit in which you have to give a notice of the potential claim, and it has to be a formal notice that you have to follow strict guidelines under Georgia law that allows them the opportunity to investigate the claim. It appears that they're aware of it, but you may not have given that ante litem notice. I would suggest that you contact a trial lawyer. Bill Sussman or I are trial lawyers that could help you in a situation like that. Bill, you agree that these things, she needs to get some help at this point in time?
Well, you have generally a 2-year statute of limitations in Georgia to file a lawsuit, and what Vic is talking about in terms of a claim against a municipality, an authority, a city, a county, or a state is that within that 2-year statute there's inside limits for notifying them, which is called ante litem, which means prior to litigation they have to be put on a legal notice that there's a claim. And sounds to me like you just need to keep calling because there certainly would be plenty of attorneys, especially in Atlanta, where there's many attorneys. And in fact, if you want to call either me or Vic tomorrow, we can certainly give you the names of several good trial lawyers in the Atlanta area that would handle this case. But in general, if you want to go back to generalities, obviously you try to record as much of the fall as you can, and there obviously are airport cameras that probably captured your fall. And the main thing is you want a lawyer to put them on notice that if there are video, you want them to preserve it. It's called a spoliation letter. And if you put them on notice right away that you want them to preserve the video, and they don't, that's a separate action that can be made against them, a separate element of damage. So I would keep you need to get an attorney, basically. Slip and falls are not an easy thing to handle on your own.
Sure. Before we head to the break, time for one more quick call. Janice from Augusta. Hello, Janice.
Hi.
What is your situation?
My question is, if you're renting a house from a landlord and the house is one where the foundation is cracking or sinking and the floor has been replaced twice, but you still notice that the floor is uneven, it has some very serious soft spots in it, what recourse do I have if I slip and fall?
Bill?
Well, I think the first thing you should do is send the landlord a letter, putting him on or her on notice, written notice that there's a defect in the premises. There's a soft spot in the floor, it needs to be repaired. You're concerned about being injured, it's an unsafe condition. Of course, you're also acknowledging that you're aware of it as well, and so you have a duty, of course, to avoid any harm to yourself. But I think ultimately the landlord is responsible and needs to take the appropriate precautions.
Okay, well, after a short break, we're going to take Kevin's call from Martinez about kids playing football in his front yard. Please stick around. You're watching News 12 Law Call. Well, thanks so much to attorney Bill Sussman for appearing again on Law Call. If you'd like to reach him tomorrow, call 706-724-3331, 724-3331. And as always, you can reach a representative from the Vic Hawk Law Firm in downtown Augusta at 706-722-3500, or you can look them up on the web, vichawklaw.com. Well, we're rejoined again by Bill Sussman and Vic Hawk, and we wanted to get right back to the telephones where Kevin from Martinez has been standing by very patiently. And Kevin, it is football season, and I guess your home is the home that the area kids tend to gravitate to, huh?
That's correct. Good morning, guys. How's everyone doing? I do have a question for you all. Like you did say, Neil, my yard is often the site for football games for kids anywhere from the age of 5 to about 11. And the problem I have is that I have exposed roots in part of my yard living here in Georgia, and their field, really. And my question is, am I opening myself up to any type of litigation because of that, if they trip and fall, hurt themselves, or what have you?
Kevin, the answer to your question really depends on the individual circumstances. And in this case, are the kids there because you coached the football team or because you're setting up some kind of practice?
No, not at all.
This is just a regular neighborhood pickup game.
Right, they go from house to house.
Right.
And I have been out there. I mean, this has been going on for a couple of years, and I do say, hey, be careful of those roots.
Yeah. Well, that's good. That's very good. Generally, they're considered licensees because they're there for their sole benefit, and that's just to play a football game. And you'd only have the duty to warn them of a known hazard that might be hidden in some way, and I think you're telling them about the roots will protect you to a great extent. I have a case right now involving a root that caused somebody a very bad injury and break to their leg and serious knee injuries. But the circumstances were different in that this was a person that had come to the premises as part of the owner wanting some landscaping done in the yard. In that event, he became an invitee, and as an invitee to the premises for the benefit of the owner owner was required to make the premises safe. And in this case, the pathway leading to the front door had a root growing up from it and was not readily visible, and as a result caused the fall. So the circumstances are different in your case. Generally, these children are considered licensees, and you would only have a duty to prevent a known hazard that you knew was hidden from their view. And it's just really good and safe to just warn them that there are roots out there and be careful.
And, you know, Bill, chances are the kids are under 18, I would assume, unless they've got a helmet on and, you know, got pads or what have you. You think, should Kevin talk to the parents in the neighborhood?
Well, I think what you ought to do, Kevin, is if they're playing at other houses as well, maybe suggest to them that those houses, those yards are much better for their football games than your place, so that you don't have to worry about whether they're invitees or licensees. I would just say, you know, that your field is not suitable for the football game, and that way you don't have to worry about whether or not someone gets hurt, because regardless, you know, whether or not you're actually liable or not, someone's going to get a lawyer and make a claim against you, and you want to avoid all that if you can.
I've heard we do live in a litigious society, so that could happen for sure. You're right. Well, we want to take another call. Tom from Georgia with a pretty good conflict. How are you, Tom?
I'm doing pretty good. How are y'all doing?
Oh, sure. Good. Great. What's your situation?
Well, I'm gonna comment on Bill's question. I'm gonna reflect back a little bit because you've been off the air for a little bit here. I'm gonna wait and talk to you. But Bill, when you were asked, that lady asked you about her house, and she had some flaws in the floor, the foundation cracking. Do you remember that?
Yes, sir.
Okay. You said it was ultimately up to the landlord to fix that problem. Okay?
Correct.
And to actually get legal document saying that I have this problem in your house that I'm renting to her as I'm a landlord, okay?
Right.
So it's my house. On the same token, you didn't give her the other option is that, well, if you file this against him, he may just ask you to leave.
Sure.
She has no contract with me. It's month to month. I'm sorry, I can't afford it right now. Times are hard. You know, I evacuate the house.
Okay, well, if you're on notice that you have defective premises and she gets hurt and you fail to take corrective measures, you ultimately may still be liable if she gets hurt. Granted, you have the option of asking her to leave rather than fix the house, but you have that gray area in between when maybe she's still in there. So even though it's a month to month, you could still have some problems with that.
That's and that's really the give and take in a landlord-tenant relationship. The landlord has the duty to make the premises safe. The tenant has a responsibility not to cause their own injury. But if the tenant is dissatisfied with the premises, then they can leave the premises. If the landlord decides they don't want to rent their premises anymore, they can decide to not rent it anymore. So the gray area is where what happens to anyone during the period of time when each make those decisions.
Good, interesting case, and we've got to scoot for the evening. But yes or no, can you do the repairs yourself and take it off the rent, or no?
You can. It's always better to get that agreement up front with the landlord.
Okay, all right.
Yes.
Well, Bill, thank you so much for coming on, and Vic as well. And y'all are troopers. It's 1 in the morning. Get some sleep. We'll see you next Sunday.
Thank y'all for calling.